but I will stay as long as you need, 7, 8 o'clock, whatever it is, but I'll get you in. Any questions, anything in your minds? Yes, sir.
On your practice exams, or on your practice exams, some of the answers, some of the A+ answers are, I mean, it's easy to critique them when we have like 8 hours to do it, when we're under time constraints, so we see the errors. Can you give us a breakdown of the proper answers for each one of those questions?
No.
One of the exams?
No. And the reason why, and I think I said this during review, there's no perfect exam. It's never happened. To give you a perfect exam would be impracticable. Even the A+ answers, if you look at them close enough, have mistakes, which is actually should be reassuring for you, because I don't shoot for perfection, right? You can get the top grade without being perfect. So I give you those. I mean, it's helpful if you find the errors, but that's a realistic estimate of what you need to get an A+ answer. If I gave you an answer that I wrote, it wouldn't be realistic because I wrote the question, right? I know exactly what I'm looking for. I think the best bet is for you to read those questions carefully. If you see something that's wrong, then you're doing your job right. Okay? Is there another hand somewhere over there? No? Okay. One note, there's actually an event on Thursday at 11. So basically on Thursday, immediately after this class, the Federal Society chapter on campus is holding an event on free speech on campus and free speech and education. This is a very important issue which all we should understand, and whether or not you're taking me for con law, you should learn about the First Amendment. So it'll be me, Professor Randy Kelso, and an attorney from a group called FIRE that litigates a lot of free speech cases. Just to give you an example, at Blinn College in Brenham, there was a student I know, and she was handing out what was it, copies of the Constitution or copies of the Second Amendment, and the school basically said, you can't do this. And they said, you have to go to this remote spot in the corner of campus, hand these out where no one was there. And FIRE actually filed a lawsuit on her behalf saying that this is a clear violation of the First Amendment, and I tend to agree. So if you're free Thursday at 11, immediately after this, come. I'll give a reminder on Thursday for sure, but it'll be me and Professor Kelso, and I think you will enjoy it. Okay. Yes, ma'am. Right. So what I'm going to do for that, I haven't announced it yet, but your question is a perfect opportunity to do so. What I'll do is I want to spend the full 90 minutes going over one of my old exams. I found the best review sessions are going over the exam question. This is perhaps Carl's, an answer to Carl's question a minute ago. So what I'm going to ask you to do is, at your own time at home, to take one of my exams. Time yourself, take under normal conditions, 90 minutes, and you'll be in good shape. Come in, and then we'll go over it. If you'd like, you're welcome to come to this room at 8 a.m. and type it from 8 a.m. till 9:30. The room will be open. Notice I didn't mention that part first, right? So you can either come here at 8 a.m., take it here, or do it at home. I don't care because I'm not going to look at it. I already graded your midterms. This will be an opportunity for you to try it yourself, and I will go over the A+ answer, and I will critique, to Carl's point, if there are things I think that aren't quite right, and that may be an opportunity. I don't know which question I want you to do yet. I haven't decided yet, but I'll let you know by the end of the week. That way you have enough time to make that decision. But again, you can either come in at 8 a.m. and use this room. It's open for your convenience, or you can do it at home over the weekend. I really don't care. And that way I'll go over the exam. Okay? But yes, thank you. I was going to announce that probably later this week, but your question is right on target. Other questions? Anything on your minds? Okay, let's start then. So our topic today continues leases. And as we discussed last week during class, leases, or leasehold estates as they're called, are different than freehold estates, right? Freehold estates had this idea of livery of season, where you had to transfer this clump of dirt and you're actually conveying the entire bundle of sticks to someone. Leases convey less than a bundle of sticks, but specifically, it conveys it for a specific period of time. And we discussed there are 3 different types of leasehold estates. There's the term of years, which, contrary to the name, doesn't have to be years. It could be 6 months, 3 months, 3 days, whatever it happens to be, 5 years, 10 years. But there's a fixed period of time. And at the conclusion of that period of time, the lease terminates. No notice has to be given. You just walk out and that's it. You're good. The second type of lease we discussed was the periodic tenancy. Okay, this is what's often called a month-to-month, right? Where the lease renews every month, or I'm sorry, the lease continues month to month. This requires notice, the rules of which are somewhat complicated, but generally speaking, the law provides a specific notice you have to give. If you don't give sufficient notice, you're then bound for a full period of the new lease, and that varies by states. You can look at your notes for those details. The third leasehold we discussed was a tenancy at will. This was a somewhat complicated one where the landlord and or the tenant have the right to terminate whenever they wish. And this gets tricky when perhaps one party does, the other party doesn't. And we discussed how courts have understood it, that now at modern law, we follow the intent of the parties, and if only the tenant has the right to terminate, then that's it. We don't read it into the landlord's termination power. And then there was that other one that wasn't really a kind, but the tenancy at sufferance. This is what happens when someone holds over. They basically stick around beyond their welcome time. They're no longer in proper ownership of the land. And there are various mechanisms used to charge rent to those people, or, as we'll discuss next class, to evict them if they don't pay their rent. However, if the tenant pays his rent and the landlord accepts the rent money, that actually creates a new lease, this tenancy at sufferance. Yes, any questions on last week's class? Not too hard, not one of our harder classes. No? All right, so for today, we will talk about first what happens when a previous tenant holds over and the new tenant shows up and is like, hey, where's my property? We will also discuss the differences between sublease and assignment. And then we will finally discuss the idea of conditions that can be placed on restricting subleases or assignments. And again, next class, we'll talk about the eviction process. We're going to do the class after that. I never remember. We'll do it sometime soon. Questions? All right. So before we start, has anyone ever had the situation where you signed a lease and you showed up on the first day and someone was still there from the previous occupancy?
It wasn't a lease that I purchased my first home.
Uh-huh.
I was 21 and they were still there.
Was it the person who sold it to you?
His wife.
His wife was still there. Did the husband know about it?
No, the guy was gone. It was his wife and his kids. It was just horrible.
What'd you do?
I mean, we had already leased. We didn't have anywhere to go. I mean, we were.
You're moving everything, ready to move in?
Yeah, and we even gave them more time. And
How'd you get them out?
my husband called the police.
Oh, you told the police. And what'd you tell the police?
I mean, we had all our paperwork and.
Did they come and knock him out, or what happened?
They moved him out.
How quickly did that take?
Less than an hour.
Oh, so they.
Yeah, it was just too bad.
So in less than an hour, they got him out.
Yeah,
Was all their stuff still there?
it was channeling something.
It was what? Where?
Channel.
This city, it was a small city.
Channel what?
Channel B.
Where is that?
Near
Okay.
near Baytown.
Baytown, okay. I know there's a Buc-ee's, that's all I know about it.
It's really good.
Okay, did you have a situation too, Mala?
Mine isn't as fun as hers. But no, I was moving into an apartment, and I
Was
lived
it a lease?
Yeah, it was a lease for a year,
Mhm.
and I lived 9 hours away from home.
Oh,
So
wow.
I got all my stuff, and I come in to move into my room, and someone's living inside the room.
Oh,
So
no.
I'm chilling out in the room, and so I went down to the office, and I was like, "Why is there someone living in the room?" They're like, "It's a clear error. I'm sorry, we'll fix it." And so they moved me into a different apartment, and I asked them, I was like, "You should take something off my lease because I was promised this apartment."
Ah, smart. And did they give you something off?
Yeah.
Rent reduction or something? Or okay, good. So unfortunately, neither of them came to blows, right? So, but you can imagine. You can imagine, right? So Norma called the cops, right? But her husband called the cops. Her husband called the cops and this poor mother and children out into the street. Right. It was either them or me. Oh, I love. This is what law school does to you after like what, one semester. Okay. Fine, fair enough. But you can imagine how this is a very difficult area, right? You sign up to take a lease. The lease is supposed to begin January 1st. You're ready to go. You have all of your stuff. You have your kids, your family. You show up, and then there's some dude there saying, "Hey, this is mine." And you're like, "Look, I have my paperwork, right? I have my paperwork." And he says, "Well, I have mine too. And my paperwork says if I hold over, I go into month to month." So this situation with Norma and Amala was not deliberate, right? But imagine a situation where you have an evil landlord, right? By the way, in any exam question I write for you, assume, and I just want you to assume this, assume that landlords are evil and they're trying to lease the same property to two people simultaneously to collect double rent. Just assume that, right? You'll probably be right in half the cases. Maybe I'm not. Maybe one day I'll have a benevolent landlord. But imagine if you're a landlord, right, and you're trying to maximize the amount of money you're going to get. So, okay, clerical error, right? So you're renting one to Amala, you're renting one to this other person, you're giving this to Norma and this other family, right? So what do? Norma shows up, says, "Hey, that's my apartment." And the guy says, "Whoa, look, I have papers too." You call the cops. The cops say, I mean, look, what do I know, right? She has paperwork. He has paperwork. I mean, it both looks legitimate. It seems that the landlord's a crook. What then, right? Can you evict the tenant in place if he has this month-to-month agreement, his checks are being cashed, to move in Norma who hasn't been living there? So you can imagine the situation arose a lot at common law, okay? And that's actually the basis for this case. You may say, "Oh, it's so easy, just call the cops and the cops will straighten it out." Well, if they both have valid paperwork, you know, what are the police supposed to do? I mean, they're not judges. They can't they can't adjudicate that sort of dispute. They'll say, "I don't know, you guys figure it out." That's why the common law developed the way it did. So let's go on to the first case, the Hannan versus the and Dusch, pronounced Dusch. Let's do the first case. So where did I finish up last time? Okay, thank you, Jonathan. Please tell me, what were the facts, please, in the Hannan case?
Yes, we have a relationship between a tenant and a landlord. Hannah is the tenant that entered into a lease that was supposed to start on January 1st, 1928. The lease was supposed to be for 15 years. The problem was whenever he moved in on his date, there was another tenant holding over.
Good.
And the issue is there's no covenants in place.
Okay, good. All right, good. We'll get to you in a second, but Jonathan, let me ask you a question. Does a fact make clear whether or not the holdover tenant had a right to be there? Is it possible that he was a tenancy at sufferance where he was paying the rent and the landlord was cashing it? Okay, so I know it's really easy to just fault the guy who was there earlier, right? Oh man, this guy's a jerk. But the law provides holding over, right? The law provides a mechanism by which people can legally hold over. So don't just jump and assume that the holdover guy was evil, right? Maybe here again, the landlord was screwing around and was trying to double dip. So keep that in mind. Oh, Jessica, your timing's perfect. Oh, saved.
Well, because this actually
All right,
happened to
Chris,
me once before, but I was actually next from last class.
Oh, did I skip this row?
Yeah.
Oh, I'm sorry. Well,
because if not, it's
oh man, Jessica got a serious reprieve. Okay, you know what? Then I'll. Crystal. So did I call on you, Lily? Oh, she's shaking. No. You know, I actually, you know, in fairness, I had a student in my common law class who sits right there who told me the same thing. For whatever reason, I skipped this row. I don't know why. The close. I don't know. They're close, too close. Like, you know, the T-Rex. I can't see them so close. I don't know. All right. So Lily, I'll ask you. Jessica got a reprieve. I'll come back to you later. It's okay. No. So it's a funny story. When I was in second grade, you never forget these things. My teacher forgot to give homework, and I said, "You didn't give homework assignment for today." I was that guy. So I respect. I still remember. I remember just on the school bus ride home, and I went to school in Brooklyn, so you can imagine it was a different school bus. But the school bus ride home, people were like, "What's wrong with you?" I'm like, "Well, she didn't give us the homework. We had to get a homework."
It's not that.
I won't even ask. All right. Lily, okay, you're up now. I appreciate the honesty. So Lily, so when the gentleman showed up and was like, "Hey, I got my lease," and the other guy was there, what happened? Yeah, what happened? What was the conflict when the new tenant moves in, says, "Hey, this is mine," and the other guy was still there?
The conflict was between the guy that was trying to move in and the guy was still there. Right? You're talking about this.
Yeah, yeah. What happened?
Oh.
You had a holdover, right?
Yes.
So what was the conflict?
So he sued.
He sued who?
He sued the he sued the tenant. No, he sued the landlord for breach of
Okay,
contract.
so this is important, right? Why didn't the new guy, right, sue the holdover? I know, you're right. He sued the landlord, but why didn't he sue the holdover?
Maybe because he thought his dispute should be with the landlord instead of with the.
Why could he not sue the tenant? I'm sorry. Why could he not sue the holdover?
Because the old common law.
Oh, before the common law, right? Why could the new guy couldn't sue the? Why could the new tenant not sue the old tenant? Let me ask it like that.
Because the lease was with the landlord.
Ah, what do we call that?
Implied covenant?
No. There's a name for that. The fact they had a relationship. What's that word I'm thinking of?
Uh,
Privity.
Privity. Okay.
Privity. Everyone see that? Privity. The new guy, I'll just use new and old because I don't like names. The new guy couldn't sue the old guy because they weren't in privity, right? What's he going to sue for? They have no contractual relationship, right? So he sued, as Lily said, the landlord. Okay? So before we get to the facts of this case, think about this for a second, right? If the suit with the landlord doesn't work out, Brian, oh, Chris already put your row up. If the suit with the landlord doesn't work out, right, and the court rules as it did here, what remedy does the new guy have? If the suit with the landlord doesn't work out, what remedy does he have?
I'm not sure.
Okay, so the new guy wants to be put into possession of the property, right?
Yeah.
We already said he can't sue this old tenant. They have no relationship, right? They're not in privity. I didn't ask a question. That was a statement.
Oh.
I still haven't asked a question. So we said a minute ago that the new tenant can't sue the old tenant because they're not in privity, right? They don't have any relationship.
Yeah.
Okay. If the court rules, as it did here, that the landlord has no duty to make the premise available, what remedy, if any, does the tenant have left, the new guy?
Doesn't.
He's out of luck, right?
Yeah.
So everyone see what's going on here. We'll get to the holding of the case in a minute. But because he can't go and move to eject the old tenant, if the court rules against him in this case, he's screwed. His lease is basically worthless until this guy, decides to pick up and leave.
Would it be like a contract if, since he can't fulfill his side, he doesn't get the money on the other side, would basically be rescinded?
Ah, okay. So we'll get to the issue of rent in a bit, and it's funny that you analogize to the contract law. Historically, property and contract law were very different. But in the 20th century, the modern approach was to incorporate contract doctrines. So, is that Siri? No. So under the common law doctrine, it's not entirely clear that you would have a duty to stop paying the rent because he still has legal title, and that was holding the case. Under the modern approach, yes, there's a duty to mitigate. That wasn't clear under common law.
I was just actually very similar.
Oh, good.
Okay, so let's say he has to find a new apartment like now. He sold his home, he has to have an apartment, and he has to buy a more expensive apartment.
Not under the common law.
But under the modern, he actually, and let's say he has to pay more for the other apartment he gets. Can he force the landlord of the other complex to pay the difference?
That'd be a stretch. You can probably get the duty to rescind the rent, but I'm not sure if they can do finding costs. Let's try hand somewhere there. Hunter?
Actually, I was going to ask the same.
Okay, very good. I'm glad you guys are on the same page. So understand here that there is no remedy against the tenant. The only person who can sue here is the landlord, right? Okay, so now Crystal, you get your magic question, right? So what are the two approaches the court identified to resolve these sorts of holdover disputes?
The English law and American.
Exactly. There's the English rule and the American rule. All right, so start off, tell us, what does the English rule say?
The English rule kind of implies the covenant, and it requires
A covenant of what? By the way, what's a covenant?
like
you have-
promise. Like
A promise. Good. I like that. Promise is exactly right. So what does it mean to imply a covenant?
So just with the lease as it is, the lessor is not expressly saying, when you move in, no one will be here. So this English rule is saying, okay, it's going to be implied.
Who's implying? Who is doing the implication, Crystal?
The lessee.
No.
The judges.
The judges, the courts. Bingo. So let's follow me, all right? If the parties had wanted to, okay, they could have put a term in the lease that said, I promise to give you not only legal possession, but physical possession, right? Crystal, is there anything stopping the parties from reaching that term of a contract, term of a lease? Nothing, okay? The parties could have incorporated a term that says, on January 1st, whatever the day was, I promise to give you both legal possession, that is, I'm giving you the legal possession, and I'm also giving you actual physical possession, okay? The parties in this case failed to do so. And I'm sure if Norma or Amala or whatever read their leases, there was a provision there that says on the day of the lease, we give you physical occupation. I'm positive whatever you sign, that phrase is in there. I'm positive. Okay? That wasn't done here. So the English rule does this by implication. Now, you may not have thought about this. You've heard of these implied warranty of this, an implied warranty of that in contracts. But who's doing the implying? The courts. Whenever a court says it's an implied warranty or an implied covenant, that means the court is taking its red pen, taking the contract, taking the lease, and scribbling in some new information that the parties did not agree to. Okay? The court is altering the contract parties reached. Now, I'm sure in contract you said, man, that's awesome. That's so fair. You know what? This contract wasn't right until we had this term in here. But I want you to pause and hesitate for this, right? So Jamie, think about this with me for a minute, right? If you and I are, bargaining for a lease, and you say to me, Josh, I'm going to give you this lease, but there's this guy there. He told me he was going to leave. I think he's going to leave. I'm not sure, but I'll tell you what. I'll give you a discount, right? I'll give you a 50% discount on the rent, just in case this guy doesn't leave when he's supposed to, but I know he's going to leave, right? And I'm like, would you consider taking that deal? Say 75% reduction in the rent.
Like if I'm offering it to you?
Yeah. 75% reduction in the rent. Like, it's like this guy's going to leave. His mother's sick. He's going to go home, but, he just hasn't left quite yet.
That's how confident I am.
Say you know the guy. And yeah, that's Jimmy. He's going to get out of here real soon, right? Yeah, whatever. He's actually Jimmy here. Sorry. I made up a name. I have to be careful to make up names. Whoever, right? Yeah, I know this guy. He's going to leave. I mean, would you take that with a reduced rent?
If I were you? Yes. I don't know if I would want to do that.
Okay. So the point is, people sometimes make speculative real estate deals, right? It's not a sure bet, but if the rent is low enough, the parties can reach terms that are mutually agreeable, right? You fully understand that maybe Jimmy will still be there on January 1st and he hasn't skipped town, but you take that risk. But then what happens, Jamie, when the courts imply this term in? What is the effect of that court alteration of the contract? What does the court's implication do to the arrangement that the parties reached?
Wouldn't it nullify it?
How?
Because the implication is already there that the landlord, me, is going to make sure you get to go in. So, in other words,
you're gonna have to go in and not take.
No. You were thinking, but you lost it. What does the implication do to the original agreement the parties reached, the terms that they reached?
I want to say it nullifies it.
It nullifies. That's right. But in what respect does it nullify it?
Well, I keep thinking because the implication is there that the landlord has to give assure that the new tenant's gonna get possession.
Okay, I'll see. Sean, would the parties have reached the super duper low rent if they knew they had this duty of physical occupancy? Speak.
I don't get a question.
Would the parties have reached this agreement with the super low rent if there was a requirement to provide physical occupancy?
No.
Why not?
Because I would have lost the benefit of my bargain.
Okay. So sometimes people make deals, right, that are risky. And they say, look, I can't guarantee that this guy will be out. So in order to compensate for that, I'll give you a low rent. And even if he's not out on January 1st, he'll be out by February, right? He'll be gone by then. When the court steps in and inserts terms into a contract, and they alter the contract by implying these covenants, it frustrates the intent of the parties, right? The parties had an intent. They had an understanding of how this would work. The court then frustrates it. That may not have been the case here, right? I have no idea what the facts were here. They said that the case is pretty short on the facts. But always hesitate whenever courts say, we're going to imply a new warranty, because the parties were too stupid to think of it themselves. And it's true. The parties were not sophisticated to think of it themselves, so we'll cover for them, right? So always think of that. Now, the flip side is that most parties are unsophisticated. That's legal for stupid, right? They're unsophisticated. And maybe courts should be in the business of implying certain safeguards. But the implication is always tricky because you're altering, you're frustrating the terms on which that lease was signed. And if you think of the case we have later today, with the airplane hangar, the court really altered the terms of the contract, and that frustrated the intent of the parties. Yeah, Hunter.
So, just so I get this right, that means under the English rule, your cause of action would be against the landlord as opposed to the tenant?
Yes, because you're basically suing the landlord to provide you with physical access to the property, even though that was not a term that you reached upon in the contract. Yes, sir.
It talked about in the English rule that it's only for the first day of your rent and not the second.
Isn't that funny, right?
And so are your damages only one day?
You're really seeking an injunction.
Oh, okay. I got you.
Right? I mean, there might be some damages for lost occupancy, and maybe you have to rent somewhere else. I don't know. But you're really seeking a court order to kick the guy out. But you raise a fair point, right? So, Amala, what would have happened if you moved in on day number 1, the apartment was empty, right? And you move all your stuff in. And then the next day, the guy shows back. I was like, oh, yeah, let's have town. Who would you call then? Your landlord or the cops?
I probably would have called the cops.
Yeah, you call the cops. So on the second day, right, once the new tenant's actually in, at that point, it's no longer the landlord's problem, even under the English rule. Right? In other words, even all of you have leases. If on the second day some guy shows up and says, hey, I'm a tenant, I'm a holdover. I wasn't around yesterday. I was going shopping, right? You call the cops, not the landlord. So this English rule is only for the first day. Okay? But I want you to remember, whenever a court implies a covenant, it makes a contract more expensive. You'll say this more next semester. The cheapest land deals are with no covenants. It's like, as is. Like, you're buying a used car and the little stickers in the window and it says like, warranty as is. You can sell land as is with no covenants, and that makes it cheap because you're basically taking a gamble. But as you imply all these covenants and warranties and this sort, you're making the land more expensive, which is, not really bad, but it makes stuff more expensive for people to buy. Okay? So everyone get the English rule. Do you want to tell me, Rafara, about the American rule?
Sure. So at least from the American rule is kind of where they're trying to read it like on the face of the contract. So they didn't pretty much saying like they didn't put the covenant in there, so it shouldn't be implied in there.
Okay, good. The American rule is read the damn contract, right? Read the lease. This term is not in here. He only covenanted to provide the legal access, not physical access. If the former tenant holds over, the new tenant and the old tenant must figure it out, even though they're not really in privy of the contract. So you basically have to try and go to a court and persuade them that the new tenant is not validly there, but that's probably not going to work. I mean, now, if the guy is just trespassing, right? If he's just trespassing, right, then you can have him evicted for trespass. But if you both have a legal claim and you're now under this American rule, it's his, right? It's his. So the court rules in Virginia, they adopt the American rule, and the tenant is out of luck until the old one moves out. And to preempt the question, if you have any doubt of which one Texas applies, the American rule. Yes, the American rule. There should have been no doubt in your minds. We fought a war over tea taxes to not follow these sorts of rules. But this cough will not go away. We still apply the American rule.
So
yeah, Jamie.
So just to give us an area, like if a landlord does, for example, lease out a property to two people with the intent of double dipping in rent, and under this rule, in other words, does he get off scot-free?
Well, the short answer is that I promise you, every single lease signed in Texas has the contract provision that says, I give you physical access on January 1st. Right? You'll study this next semester. But Texas has what's known as a form lease. You probably have all seen it by the Texas Real Estate Commission. And it has dozens of covenants. And one of the covenants is not just physical possession, but legal possession. So because as a matter of course, every lease signed in Texas has this provision in it, it doesn't really matter what the American rule says. You can always contract around it. And if a landlord puts this provision in your lease, well, at that point, you know, you can just sue on the contract, or sorry, sue on the covenant, and not worry about the common law. Right? Never forget, parties can always reach terms. They can always negotiate terms. Indeed, one of the aspects of courts implying covenants is that parties don't need to negotiate anymore. Right? They actually take certain things out of the hands of parties. So say a guy wanted to buy a piece of speculative land with someone maybe living on it. He could have taken that risk. No longer. Okay. Questions? Everyone with me so far? Okay, let's move on. Let's take a look at some of these questions on, I think 465. So, Lindsay, you want to just read number one, please? Question, problem number one.
Sure. T leases from L a large piece of open land to be used for hunting and trapping. After paying a year's rent in advance, T finds out there is no public access to the land. Neighboring landowners refuse to give T ingress and egress.
Ingress and egress, if you don't know, means enter and exit. Just, no. Okay, sorry, keep reading, please.
The jurisdiction follows the English rule.
Okay.
Has L satisfied the duty imposed by that rule?
Right, so this is a concept called landlocked property. And you may not have ever been exposed to it, but imagine someone sells you a tract of land, right? And then someone owns all the land around you. So you have this little dot in the middle, and then the entire perimeter around it, someone else owns it. You don't have any way to access that land short of trespassing, right? The only way you can get to your property is by trespassing over someone else's land. So, Lindsay, what do you think here? Under the English rule, has the landlord actually delivered possession of the land?
I think no.
Why do you think no? Well, think about it, right? Does the person have legal ownership of the land?
Yes.
Okay. Does he have physical ownership of the land? You're right, but why not necessarily?
Because the landlocked owners aren't allowing him to enter the property that he has legal.
Ah, okay, you're right. This is no different than having a guy physically on the property, right? A holdover. She can't physically enter the land absent trespass. And that is not physical access to the property. Okay, you're right. So under the English rule, there is not physical access provided. You'll discuss this next year. In the event that someone sells someone a piece of land which requires trespassing, the court will actually imply what's called an easement. What an easement means is you can literally cross over someone else's land. So it gives you basically a license to trespass. So the courts take care of that also through implication. Okay. Jacqueline, you ready number 2, please? Oh, any questions that one first? Sorry, I have to ask. Yeah.
Under, for that one, so under the American rule, because it's only physical possession, I mean, it's only legal title, it'd be valid, correct?
Yeah, if the contract was silent about physical access, then it's a perfectly valid conveyance of land. Even if you can't get through without trespassing.
So would he just have to like would he have
Well,
to go to court?
the short answer is what I said a minute ago. They can actually get what's called an implied easement by the court.
Okay.
But the court basically allows them to trespass to get to your land.
In Texas though, whenever, since they have like the American rule and that would
Even in Texas, if it was absolutely necessary to trespass to get there, the court would imply an easement.
Okay.
Yeah, Hunter?
I guess the first question is, why would you ever buy a landlocked piece or sell a landlocked?
You didn't do a survey. You didn't pay attention to what was around it. Or a survey was incorrect, and it turns out that someone actually owned the road that you thought can get you out.
And I guess the other question is, how do they decide who loses their property?
It's an interesting question. You'll do this next semester. The short answer is the court decides whoever probably has the least to lose. But you'll do an example next year where you have a piece of property and then 6 lots surrounding it, right? And which lot do you choose to trespass on? And the court just picks one. I saw maybe one other hand. Yeah, Sarah.
The person that the court chooses to be the unlucky one, do they, can they ask for some sort of compensation?
It depends. Sometimes yes, sometimes no. You'll do this next semester. I don't want to give too much away, but the answer is sometimes yes, sometimes no. All right, Jacqueline, you had a reprieve. You want to read number 2?
Sure. L&T execute a lease for a specified term. T takes possession and pays rent for several months. T then learns that L had earlier leased the premises to another tenant for the same term. T remains in possession but stops paying rent. L sues T for the unpaid rent. T counterclaims for rent already paid.
Okay, so this is a question I think someone asked me similar before. The landlord and tenant have a lease. The tenant takes possession. He's paying rent. The tenant then learns that the landlord had leased to someone else for the same time. So here again, we have the evil landlord double dipping. The tenant remains in possession. He stops paying rent. Okay, so Jack, what do you think happens here?
I mean, I think he still needs to pay rent
Why do you think that?
because he's actually using the land.
He's still there, right? Okay, you're right. No one has actually disturbed his possession, right? This isn't the case where the other guy came around and ousted him, kicked him out. He's there. He's in possession. He's got to pay rent. Okay? It would be a different situation, though, if the other guy came around and ousted him, right? Literally, physically removed him from the property. In that case, the duty to rent would not be there. Now, under these facts, what if the other guy, right? The other guy not in possession. The other guy not in possession is paying rent because, like, you know, he's traveling, whatever, and he finds out that T is there. He could stop paying rent. So if you're in possession, you still have to pay. Everyone with me so far? Everyone okay with that? All right, Jessica, at long last, you were given a 7-person reprieve, or 2, whatever it is, I can't count. So let's move on to the next case, Ernst v. Conditt. This case teases out the difference between a sublease and an assignment. Now, how many of you have ever engaged in a sublease or taken a sublease from someone else? Okay, a handful of you. Has anyone ever had the situation where you let someone else take over your apartment? That is, you gave them a sublease, and they didn't pay their rent. Has that ever happened to anyone? Oh, yeah, I'm sorry, I didn't see you. Peripheral vision doesn't go that far. Want to tell us about it?
Yeah, you didn't pay.
So you signed the lease, right? And then you saw the lease to someone else. Did you know this person?
Yeah.
Okay. And then he didn't pay rent.
Oh, he didn't pay all.
And then who was on the hook for it? Did you know that going into it?
Kind of, because I didn't have him sign anything.
Okay, so it wasn't an official sublease then.
No, guy does not.
You just let the guy stay in your apartment.
He paid me, so.
Oh, so you're doing it off the books.
He did all that.
Were subleases prohibited in your lease?
I think they may have been.
Yeah. Has anyone ever actually done an actual sublease where the other person didn't pay the rent? Thank you. I appreciate your candor. Okay. So the number one thing that people don't understand, I think Landon implied this, is that when you engage in a sublease, in other words, you're letting someone use your land. The lessee, right? I signed the lease. I'm on the hook. If my sublessee doesn't do his payments on time, I'm on the hook. If my sublessee causes damage to the unit, I'm on the hook. Okay, and don't forget that part. An assignment, in contrast, is different. With an assignment, the lessee hands over his entire bundle of sticks to someone else. The lessee hands over all the sticks, the entire bundle, to someone else. Okay, so if this new person doesn't pay rent, I don't care. I'm out of the picture. I gave away my. I have no more interest left. Okay, so stating the difference between the sublease and the assignment is actually fairly straightforward. What makes this complicated is to try to determine from the written document which is which. And what makes this more complicated is that even if, as we'll see in this case, even if the parties call it one thing, they use the word sublease, the courts may interpret it to be an assignment based on what's actually being conveyed. Everyone understand that, generally speaking? All right, Jessica, can you run us through the facts, please, in the Ernst case?
Okay. The complainant leaves actually a certain tract of land and to Mr. Rogers
Okay.
for a term of 1 year and 7 days.
Okay.
And within that agreement, I mean, besides the rent, there was an annual amount of $4,200, but then monthly they had to pay like $350.
Okay, I'm not so concerned about the rent. In terms of under the original lease, were they allowed to assign or sublease the original lease?
No, they had actually one that says that they needed like the permission and the written approval of lessors before they could sublet.
Okay, very good. I'll come back to you in a second, Jessica. So we have this lease right here, right? This was the original lease signed between Ernst and Rogers. They want to build a go-kart track, whatever, right? And it says, in paragraph 5, lessors have no right to assign or sublet the lease premise without prior written approval of lessors. In the event of any assignment or sublease, lessee is still liable to perform the covenants of this lease, including the covenant to pay rent, and nothing herein should be construed as releasing lessee from his liabilities. Okay? So, actually, Jessica, good. Serenity, let me ask you a question. Here it uses the phrase assign or sublease, like interchangeably, right? To assign or sublease. With an assignment, is the original lessor still on the hook to form covenants and these other things? No. So this is why people screw this up. All right? They use the word sublease and assignment interchangeably. And they say, even if you assign it, you're still on the hook for these various covenants. That is not correct. With an assignment, the entire purpose is you're giving your entire bundle of sticks away. It's like, look, I'm out. You guys take care of this yourself, not my problem. Okay? So this was the first one. So Serenity, let's move on to the second lease that was signed in 1960, right? What was the impact of the second lease signed in 1960?
I'm not sure.
You do the reading?
No.
Okay, Bianca?
What was the effect of the second one?
Yeah, what was the effect of the second lease in terms of an assignment or sublease? What happened in the second lease?
They added another portion.
Good. Okay, but what was the new provision? This is on 466, by the way, in your book.
He gave them 1 acre that currently wasn't used for business purposes. So
Uh-huh.
they could use it for those purposes.
Okay, good. What else?
It said that the lessee would build no parking signs.
I'm thinking about the important thing relevant to this case. I don't care about the parking signs. Right? What was like the main thing about this new lease did?
It's subleased to Conditt.
Good. Okay, look at paragraph 5, right? So this new lease in 1960 modifies the other one, right? So we don't actually care about the first one. First one, doesn't really matter anymore. Look at paragraph number 5. If it's too small in your book, it's on page 466. Paragraph 5 says the lessor consents to subletting the premise to Conditt, but on the express condition, understanding that the original lessee, Rogers, will remain personally liable for the faithful performance of all the terms and conditions of the original sublease and the amendment to this original lease. Okay. So Bianca, what word do they use? Is it sublease or assignment? What word do they use here? Okay. They use the word sublease, right? And they also say that Conditt is liable for the performance of all the conditions in the lease, right? All right, so Landon.
You may say the other guy.
I know what the hell. Let me ask you a question first, okay? So if you just read paragraph 5, right? If you just read paragraph 5 by itself, nothing else, just paragraph 5, what would this look like to you?
A sublease.
Right. If you had just read paragraph, why is that? You're right, but why would it?
Subletting.
Okay, it says subletting, but beyond that, who's still on the hook for stuff under this?
Conditt.
Who?
Rogers.
Bingo. So if you just read paragraph number 5, this looks like a sublease. It says sublease, right? The word sublet is in there. And it says the original lessor, Rogers, is still on the hook for stuff. Okay, so Landon, you answer my next question. Why does the court go ahead and hold that this is not a sublease, but an assignment?
I think they said that they would look at the intention of the parties.
Okay, good.
Virginia law.
Okay, good.
And well, an assignment conveys the whole term, I guess.
Okay, good. Okay, good. So the court says, look, we're not going to be fooled by what words people actually use. In fact, we're not even going to be fooled by how people describe their own transactions. What we're going to look at is a bundle of sticks. We're going to look at the bundle of sticks. And in this situation, okay, the entirety of the term was conveyed. Whatever the amount of time was left in the lease, they conveyed all of it. They conveyed the entirety, all of it. Therefore, they said, it's better viewed as an assignment. Rogers gave up his entire interest in the land. Rogers had no right of reentry. He couldn't go in there. Okay? Conditt had the complete right of possession. Right? But let's see. Graham, what about this business where it says here that Rogers remains liable for performance of all the terms and conditions of the lease? Seems here he has some duties, right? How's the court treat that?
As in, like him assuming all the liability.
Oh, wait, no. You said something differently. All it says here is Rogers remains liable for the faithful performance of all the terms and conditions, right? Why would that? How is that consistent with an assignment if he's still on the hook for these sorts of duties?
So if an assignment leaves no interest or reversionary like interest or anything like that.
Right.
So I guess the agreement explicitly states it.
Okay, so the first thing you said is exactly right. Under an assignment, there's no reversionary interest, right? But here it says yes, certain covenants. Is that permissible with an assignment?
don't think so.
What does the court say? What does the court say? This is an assignment or sublease?
I think they use sublease, but it's an actual assignment, right?
Yes, the court holds it's an assignment. So the question is, how can an assignment be consistent with Roger having these leftover duties? That's my question.
Because I guess because Conditt doesn't have any express or implied rights.
Mm-hmm. Cameron, you want to take a stab?
Because it leaves Rogers reversionary interest.
Well, if Rogers has reversion, then it can't be a sublease, can it?
Yeah, so that's why it's not.
Is there reversionary interest here?
That's what it was.
No. No. Want to take a stab, Natalie?
Well, when I was reading, as I understood it, the court was looking at the amendment as an extension of the lease that Conditt took over. So even though the language here was indicating that he was still liable, the actual, I guess, amended lease is what they were really focusing on.
All right, now let me ask a question like this. Does Rogers have any right to re-enter the property here? Does he have any right? How can he perform the covenants if he can't enter the land? Oh. Right? Remember one of the covenants was to like fix the driveway and like remove these various, asphalt, whatever, right? Can he legally even enter the property to do those things? I'll get you in a second. So everyone see this, right? Even though the lease says, oh, you have all the covenants, do all this stuff on the land, he has no legal right to be there. He would actually be engaging in a trespass to go onto the land and rip up the asphalt and, fix a parking lot, whatever else he has to do. So basically the court says, oh yeah, but that language is not operative, right? It doesn't have any meaning because he can't do it. That's how they get around it. Do you have what's up?
No, I was just going to say it's because it's impossible because he has no right.
It's impossible. Because he has no right of entry, he has no reversionary interest here at all. He can never re-enter, right? Whereas Landon, if his buddy starts, making a mess and screwing up the apartment, he can go in there and fix it because he still has a right to the apartment, right? If any of you ever sublease your apartment, don't tell your friend this, but you have the right to re-enter. If they start screwing stuff up and causing damage to the unit, you can go and say, all right, I'm going to fix this so I don't have to get stuck with the bill. Rogers does not have that power. So on the totality, the court says this is best viewed as an assignment rather than a sublease. He's giving away the entire bundle of sticks. Makes sense. Even though it's called a sublease, right there, paragraph 5, these words sublease, right? The word's in there. It even says he has these various covenants, but because there's no reversionary interest, the court reads it as an assignment.
In the previous example, when the court implied a duty, it's like they were writing something in. Is this where they're kind of
Crossing it out.
Crossing out.
Yeah. Courts often insert and strike out words into contracts, right? Remember the case we did a few weeks ago with the old man who died and he's dying, he's pointing at this and pointing at this, and they basically alter the arrangement. Courts frequently alter arrangements. This is how they read it. But by the way, the reason why this is typical is because very often parties who make these who make these agreements don't know the difference between a sublease and assignment, and they use the terms interchangeably. And because there are such different legal principles with each estate, the courts have to come in and settle it. So with this decision, right, the court is basically sending a signal. This was, I think, the Supreme Court of Tennessee or the appellate court. They were sending a signal that, look, if you don't make this clear, we're going to treat it as an assignment, and we're not going to bind for rent the original lessor. So it almost creates a presumption that you have to be very clear giving a sublease. Although I'm sure here the parties thought they were. So, or maybe they had no idea what the difference even was. Most people don't know the difference before they take this class. I didn't before I took property. Questions? Okay. There's a very lengthy discussion of privity. I don't want you to worry too much about this. You will study privity of contract and privity of estate next semester in Property 2 when you do covenants. And to give you a preview, it's very complicated. and I don't want to bore you with it. In fact, there was a footnote where they know that the court actually messed up and confused it too. So if they're confused with it, I don't confuse you any more than you need to be. So don't worry about this for now. You'll get to it next semester, and hopefully it'll make a little bit of sense then. Yes, Elizabeth.
Isn't this at odds with the American rule? Before, because wasn't this something they used to bargain for? The landlord felt more confident because he had.
The backing, right?
Right.
Exactly.
And then the lodgers agreed to be liable for the rent and was allowed to kind of get out of his contract. And
Yeah.
I was gonna take that away.
So Elizabeth is exactly right. Whenever courts start taking the red pen out and altering leases, they're frustrating the intents of the parties. I'm almost positive in this case, the reason why they agreed to the sublease or assignment was because they knew who Rogers was. And that, it was a beautiful day in the neighborhood and Mr. Rogers would back them up, right? But by the court doing this, it frustrates that, I think it takes us to imagination land, or the land of make-believe, if you will. So it's really frustrating. You get the last one. Remember the land of make-believe? Wasn't that it? Mr. Rogers' neighborhood? Some people were nodding. Remember the trolley went to the land of make-believe?
It's been a while.
It's been a while. I don't have a cardigan, so I can't do it that. Okay, so. Anyway, all right. So any more questions on the second case? But yeah, Elizabeth, you're exactly right. It frustrates the party's intent, no doubt. Yeah, Jessica.
Did the court weigh in the fact that it was, Rogers was selling his business? Is that what it was?
Would it make a difference if this was business or residential?
It was not because the only reason why he kind of has to not sublease, but they put assignee or sublease. It was because he was selling the business.
Why would that make a difference in your mind?
In my mind, it's because when you sell your business, everything goes with that business.
Oh, I see what you're saying. Well, perhaps, but maybe another reason why the court read the contract in this fashion was because this was a business and not residential, right? Imagine if this instead of was a go-kart business, this was Landon subleasing his apartment to his buddy, right? The courts would more likely read that sort of arrangement as a sublease because they have this sort of private relationship. Whereas an assignment, business entities come and go. You have one go-kart business, you have another go-kart business, right? They don't consider them working together. Does that make sense? Which is a perfect segue to the last case. Kendall versus Pestana. Where was it up to? Elizabeth, you're next. All right. So please tell us the facts of the Kendall v. Pestana case.
Okay, so it's concerning an airplane. The original owner is,
Uh-huh.
and so he leased it to Bixler.
Good.
And then Bixler sells the business to
Good. Yeah. Got all the names right.
but in the lease, it says that Pestana has to approve any assignments.
Okay, good. So I'm sure you've all had a residential lease, which maybe you've read, maybe you've not. I don't know. I stopped reading them years ago. But when I used to read them, there always had a provision saying that subleases are prohibited unless you have the owner's written consent. Right? Have you all seen that sort of language? Okay. When it says the owner's written consent, that means you can't do what Landon did. You can't just have your buddy sleep on your couch and start charging him rent, right? Okay. The reason, or let's go on, Kenneth, why do you think landlords usually require the written consent before they let someone else assume your lease? Good, right. What's the risk when someone else comes in, they swap tenants? What's the risk there to the landlord? Well, it's not just not getting paid because they can always go after Landon, right? What's, though, the major risk they want? What's the concern of why they may not want someone else coming off the street?
certain standards of
Okay, good, right? Historically, at least, maybe not now when you have these massive leasing companies, right? But when a tenant gave an apartment to a landlord, they had some sort of personal relationship. It's like, oh yeah, I know Landon. He's a good guy, right? I want him in my building. Landon's friend's a jerk. I don't want this guy crashing around, right? So historically, at least for residential purposes, leases were very personal, very private. That you give a lease to someone and that you're now in this privity, you're in this relationship. But when there's a sublease, you're dividing that privity and bringing some new guy in, and maybe his credit's not as good, maybe he has a bad reputation, maybe he won't take good care of the property, maybe he has a criminal background. You know, you can imagine 100 different reasons why a landlord would not want to give a piece of property to this new guy. So this is why written consent is necessary, okay? But Christine, does the landlord have any obligation to agree, for residential purposes at least, to bring a new tenant in? Are they required to agree? Very good, right? So historically, a common law, the landlord was under zero obligation whatsoever to accept a new subleasee. Zero. I mean, there was no obligation. The landlord said, you know what? I don't like this guy. He has bad credit. He has a criminal background. Wears a funny hat. I don't know, right? I'm not going to give it to them. There may be some laws concerning racial discrimination otherwise, but I'll put those issues aside for the moment. But then we come to California, right? And Christine, what did I tell you about any case from California? What are they about to do? Well, no. Generally speaking, what does a California court do to the common law? Generally speaking, they reverse it, right? I think I told you this a few weeks ago. It's I think in every case in your entire book, if it's from California, they're about to reverse a common law. But maybe I think of like 2 or 3 exceptions, but virtually every case, if it's a California decision, they're about to reverse a common law, right? All right. So Jimmy, tell me, how in this case does the court view this common law rule that the landlord can reject consent under any circumstances?
I think it's unreasonable.
Okay, why do they think it's unreasonable? Actually, and in fairness to California, I often beat up on California, but in fairness to California, this is a pretty well-reasoned opinion, right? There's actually a lot of reasons why. Agree or disagree, fine, but very often they say, oh, it's not fair, live your season, clump of dirt, done. So here they actually try and give you some stuff that has, you know, some meat. So Jimmy, walk me through, at least for starters, why do they think that this provision is unfair?
It's mostly because of they talk about the dual nature of a lease and how it's part conveyance and part contract.
Ah,
and the
good.
mixture of good faith and commercial viability.
Very good answer. So you've all taken contracts, so you understand how much in the restatement and UCC this notion of good faith is like the cornerstone of contract law, right? You've all studied this, right? Property law at common law was very different than contracts. If you've noticed, the entire semester you've been with me 20-something classes, have you ever used the word good faith? Have you ever used the word fair dealings? Have you ever even like mentioned these things, right? No. The reason why is that historically property wasn't fair, right? Think of all the determinable estates where if like one day you forget to do a certain act and then you immediately lose a property. I mean, if you serve alcohol because you forgot a covenant signed 100 years ago, you lose the property immediately. There's not even a court proceeding. It's like, boom, you're out. Property is not fair. Property is not fair. Think of the first case we did, Pearson v. Post, right? You have this guy hunting with his foxes and his dogs, and he's about to get the stupid fox, and this jerk swoops in. Jerk gets it. Why? Well, it's certain he had it. It was in his hand, right? Property is not fair. Courts don't like that. Courts like equity. Courts like fairness. This is why the UCC, the Secondary Statement of Contract, have all built in this notion of good faith and fair dealing, right? The duty to mitigate, right? All these doctrines, unjust enrichment. Does property have an unjust enrichment doctrine? Of course not. There's no such thing. We don't have that. But in the 20th century, and Jimmy's exactly right, in the 20th century, courts gradually began reading elements of contract law into property law. And this wasn't done through statute for the most part, right? This wasn't like a legislature adopted the UCC, which is what happened in most states. Courts did this by common law. And you can see it here. And Jimmy said exactly right a minute ago. The courts say, well, you know, a lease, it's partially property law and it's partially contract law. Where did they get this from? I don't know, but it is now in California. Mazel tov, you have a new doctrine, right? So we have this entire idea that we're bringing in contract law. And once you import contract law, you have good faith, fair dealings, duty to mitigate, unjust enrichment, you know, go down the list. The courts never got this for freehold estates, right? So when you're actually buying something in fee simple, the traditional property rules still apply. But courts seized on leasehold estates. Why? Because a lease and a contract look very similar. It's for performance for a specific period of time. By the way, remember the UCC does not apply to property. Remember, I'm sure you studied that at some point. Courts did it anyway, right? So even though the legislature said we will not apply the UCC to property, the courts did it anyway, such as the common law. So they start bringing in these various contractual doctrines to property law. They start implying these various covenants, which is something courts do all the time in contract law. In fact, they actually cite the UCC, saying we're going to look to the UCC for a good faith and reasonableness. Okay? Again, I don't think I ever use the word reasonable the entire semester. I'm glad. I don't like reasonableness is fluff. It's like, oh, whatever, right? It's fair. But here in I like property because there's actually rules, right? Unlike other classes, there are actually rules I can teach you. I don't have this in every class, but this class there are lots of rules to teach that are pretty tight. So they move ahead. So they bring in this contract doctrine. So any questions on that? And you'll see this in the last couple classes. Basically, all about good faith, fair dealings, duty to mitigate, etc. Everyone okay with that? So the court walks through 4 reasons. So this is why I say I like this opinion. They give reasons. Not always the case. 4 reasons why they should abandon this old rule. Okay, so Christian, you want to walk me through the one of the reasons, or the first reason, please?
Well, the first was that the lease is a conveyance of an interest in real property, having exercised personal choice in the selection of a tenant. No substitute shall be accepted without prior.
Okay, well, in your own words. Don't read, yeah.
So, yeah, he's saying, well, I had the right to choose a tenant. I should keep that right.
Okay, well, that's the reason for the common law rule. Now, what's the response the court gives of why that should not be followed? And in your own words, please.
I guess you're trying to say that, well, if you have a duty to mitigate damages, then like, if somebody's trying to sublease, then that's just a
Okay. We see what he just said. Exactly right. Landlords, under this new contractual law, have a duty to mitigate. And if they have a duty to mitigate, what difference does it make who's in your building, right? You can't keep the old person on the hook for rent if someone else is willing to pay for it. The reason why this rule works, again, is because of a duty to mitigate. If the landlord had no duty to mitigate and would say, listen, you signed the lease, I'm not transferring it, you pay the rent or I'll sue you. And I will leave this building empty, right? I will leave this building empty until you pay your rent. Well, in such a case, this rule makes sense. But once you say the landlord has a duty to rent it to someone else, then it makes a lot of sense. Sure, let him sublease, right? Why are we making him pay for property he's not even using? Let someone else come in. What's the big deal? But this is premised again on this duty to mitigate, which is contractual doctrine. Everyone get that? Jesus, you want to tell us about another reason the court gives? Right. So Jesus, let me ask you a preliminary question. These are sophisticated businesses, right? They're in an airplane maintenance business. It's not like mom and pop hardware. So there's like a sophisticated business at an international airport, right? Could the parties have reached an agreement that said the landlord will consent to any sort of reasonable request for sublease? Could they have reached that agreement? Was there anything stopping these sophisticated business parties from reaching that sort of agreement. Why didn't they? Right. Think about it. That clause is expensive. If I'm the landlord and the tenant says, I want you to put this reasonableness clause in, I'm going to jack up your rent. If I'm not going to have a say over who to accept or reject, I'm going to make this more expensive for you. The parties agreed to this general provision in order to save rent. Okay? Now, the court gets around this in a somewhat fuzzy way. They say, listen, even if they put this reasonableness clause in there, that doesn't necessarily mean it's easy to interpret, right? It can be withheld in certain factors by saying, oh, I don't think that's reasonable. So the court basically says, even if you put this reasonableness language in there, that doesn't resolve the dispute. This part's ironic because the outcome of the case is the court inserts the contract. So here they're criticizing this reasonableness language, and they say, but we're going to insert it anyway. I don't quite get that. Does that make sense? Okay, everyone get that, right? You want to go on to the third one? I feel like I'm in the wrong class today. Stare decisis, George. Oh, I'm sorry. Yes, please, Josh.
So the previous traditional majority rule used the phrase commercially reasonable. Then it says the restatement of torts just says cannot be withheld unreasonably. So do they switch it away from being commercially unreasonable, or do they still imply it has to be commercial reasonable?
You know, not only are they taking from contracts law, they're taking from torts law. And the problem here is that in the UCC, you recall there's different standards for commercial businesses and non-commercial. Remember this? Torts doesn't have that same distinction. So it's just a hodgepodge. It doesn't matter. You know, remember that show Whose Line Is It Anyway, where points don't matter? Yeah, California. So, George, how does the court approach stare decisis? Because this has been the rule for a couple hundred years, right? How do you reconcile this with the court's duty to stand by precedent? Stare decisis literally means stand by decision, stand by precedent. I guess Lawrence and Windsor today, so I got to talk about this in an hour. But yeah,
they say that even though it's a majority rule, that they have never adopted it. That the trend.
The trend. This is the joy of common law courts. The trend is moving in this direction. Why is the trend moving in this direction? Because other courts say it's moving in this direction, right? So if one court does something, and then a second court does something, we got a trend, right? And not only is there a trend, but you as lawyers are responsible for noticing that trend. Even if the law of your state says X, you have to be aware of the law in 49 other states of where it's moving. So let me ask you a question, Matthew. Let's say you're a California lawyer, right? And you were advising the landlord here. And he asked you, saying, listen, I only want Bixler, whatever his name was, right, to have this property. You know, I don't want him giving it to someone else. I like him. We have a good relationship. And he says, if I put this clause in my contract that says I can withhold consent under any circumstance, is that enforceable? So what would you have told your client before this decision? He walks into your office and says, listen, I put this term in. Can I, reject any tenant for any reason? What would you have told him? Okay. Did you engage in legal malpractice by giving him a flatly wrong statement of law? Well, exactly. At the time. This is why California is such a difficult place to practice law. Think about this. When the common law, which has been existing for a couple hundred years, is being changed willy-nilly, it puts lawyers like Matthew in a tough spot because he gave good legal advice, right? At the time he gave the advice, solid. You did your homework, you researched it, you gave him a good answer. Now your client goes like, Matthew, what the hell, man? You told me I don't have to do this, and now I get this judgment. I'm going to sue you for malpractice. This is a problem when courts start changing the common law. I mean, law students don't think about this, but if you were an attorney in California, imagine a couple years out of law school, right? You got a big client, this guy who owns an airplane hangar. He goes to you, oh yeah, Josh, can I withhold consent? Oh yeah, put this language in, right? This has been upheld by all these other courts. There's some other state court decisions in other states, but don't worry about those. They're not binding in California. Or if you're a California lawyer, you say, well, under the law as exists today, that's right. But there's a trend, right? There's a trend. Massachusetts did this and Vermont did this. And yeah, California is probably going to screw you over in a couple of years. So as a California lawyer, you should probably anticipate that these various common law rules will be abandoned. And say, just in case, put a clause in here. But even if you did, the court would ignore it anyway, so it doesn't really matter. Right? The court would say, well, even though you put this language in, it's still not fair, so we're not going to read it. It's hard to be a lawyer, right? It's hard to be a lawyer when rules are in flux. If I may quote another decision, liberty finds no refuge in a jurisprudence of doubt. There's the first sentence in Planned Parenthood versus Casey. I think I cite that improperly, but it fits. Okay? So everyone get that, right? When courts alter a thing, when they don't stand by precedent, it makes it really tough for you guys as lawyers to make to make advice. Yeah, Hunter?
Isn't common law always leaving at that?
Well, there's a difference between the gradual accretion of common law versus the sudden reversal of precedent, right? There's this great image, I think it's from Lord Cook, that says the common law works itself pure. That over decades and decades, there's very slow, gradual changes. What we saw in the 1950s, 60s, and 70s was these sudden reversals of long-standing doctrines because of this fairness, right? So the common law evolved in such a way that people's expectations were not disturbed. This decision, if you think about it, amended every single commercial lease in California. Every single commercial lease in California that said the landlord could withhold consent now had the word reasonable added to it, right? As if the court had taken a red pen and put the word reasonable in every single lease in California. That's a big deal, and not something a common law court would have ever conceived of to move that radically. Especially for two reasons. One, these are commercial parties. Commercial parties are deemed to be sophisticated. They could have reached agreement. In fact, they didn't suggest that they didn't want to. And the second reason, this is something the legislature can handle. They can amend the property code to imply warranties by code. We live in a world of court decisions, but they're not the only actors in our democracy. And indeed, after this case was decided, the legislature passed a statute codifying this holding. So they could have done it in the first place. Perhaps the big difference is they would have made it retroactive. The legislature could have said, all contracts signed after this date had this new rule in place. But the court's holding was retroactive. So now all these old contracts can now be opened up and modified by the court. So that's one of the problems when courts start modifying common law. It applies retroactively. And now all courts must interpret those contracts consistent. And indeed, the dissent, which wasn't really long, but the dissent basically said, let the legislature do this. It's the perpetual debate in courts. So questions on the Kendall case? Yes, Sarah?
Out of curiosity, what does Texas follow? Is it this rule or?
I'm not sure. I could probably check. If I had, I say with a strong degree of confidence that for commercial lessors, you follow the text. I'm with high confidence I can say that, but not 100%. With high confidence I can say that they have not followed this California trend. For residential leases, it's still the case that landlord can withhold consent. For commercial leases, though, it's perhaps a different story in California. But I'm pretty sure I'm right, but I'll look at that later. And Jamie?
So again, this is just a minority rule? Or
for commercial, I say this is a minority rule. I'm not 100%, but I think that's a pretty good statement.
So on the exam?
I knew that question was coming next. Unless I say you're in California, don't apply this rule. Right? This is not going to be the common law rule. If I say you're in a common law jurisdiction, don't apply this rule. Students love us, and so on the exam, it's always a follow-up. With good reason, you want to know what to write in the paper. I get that. I understand. I understand the apprehension. All right, questions. All right, so let's summarize a little bit to wrap up. The general movement in leases is towards the incorporation of common law rules. So we start with the first case, as Hannan versus Dusch, which is this old Virginia case where they don't care much about fairness, and they apply this American rule, which is we follow the terms of the contract. They could have negotiated to put in a provision to allow physical access. They didn't. Too bad. The English rule implies covenants. That is not good for us. But then we see this trend with the always trends in Ernst v. Conditt. Even though the party said we'll do a sublease, well, there was no interest left over, so it was actually an assignment. And the last one, even though the parties contracted that consent can be withheld for any circumstance, they held, well, it must be reasonable. So in the last, I guess, 4 or 5 classes we have together, I will be saying the word reasonable a lot. I'll be saying the word good faith a lot. I'll be using the word fair dealings a lot. I don't like it, but I'll have to, because that's a trend where the court has gone. Questions? All right, I will see you on Thursday, and have a wonderful day.